What's going on, everyone? We're back with part 3 of our series discussing sports and recreational injury cases. Today I want to talk to you about defenses. We know that in sports, defenses win championships. In these types of cases, defenses can sink your chances of getting relief for your client. And I want to talk to you about specific defenses for recreational injuries. The first is assumption of risk. This is the granddaddy of defenses. It applies to almost every recreational case because the theory is if you are engaged in any activity that involved risk, you deserve, essentially, whatever injury came of that activity. Now, I would challenge you to think about what really caused the injury. Was it the fact that this person engaged in a certain sport or recreational activity, or was it the negligence of a third party? Was it the failure to warn your client about some dangerous condition? Really dial in and think about what caused this injury, because oftentimes that risk was not assumed by anyone. I would suggest a book called There Are No Accidents. I think it's a great framework to really challenge you to think about what contributed or caused an injury outside of the specific actions of an individual. When we think about it from that framework, we can better make these activities safe. Think about it. If a condition created the injury, that's an environmental condition, and someone is hurt, if we point the finger at the individual, but the condition remains, that same injury can happen again and again. So definitely take a look at that. The next defense I want to talk to you about is recreational use immunity. Many states have these statutes. We have one in Washington, but essentially provides limited liability for a landowner who opens up their property for recreation. And this comes up if it's a premises case that you're dealing with, if there's a condition on the land that made the activity or the area dangerous for your client. And so you have to be aware not only that the statute exists, what is required of the statute, how someone might take advantage of it, but also the exceptions, drilling down on those exceptions so that you know what you have to plead and what your experts have to back you up on when you're thinking about evaluating a case. So those are a couple of pointers on defenses I wanted to lay out for you all here. I hope you found this series helpful. If you have any questions, feel free to connect.